Hi there, college friends. I'm Wilmar, and today we're going to dive into the world of software product liability. Have you ever wondered who is responsible if a software product causes harm or loss? Let's find out. Product liability involves the responsibility of manufacturers, sellers, lessors, and others for injuries caused by defective products. In the United States, product liability is mainly governed by common law and the Uniform Commercial Code. Imagine a future where self-driving cars are common. If there's a malfunction in the electronics or software of these cars that leads to injuries or property damage, product liability claims may arise against the vehicle manufacturer or a supplier of a component. Software product liability claims can be based on different legal concepts, such as strict liability, negligence, breach of warranty, or misrepresentation. Let's take a closer look at each of these. Strict liability holds the defendant responsible for injuring another person, regardless of negligence or intent. All parties in the distribution chain can be sued for injuries caused by the product. Negligence is the failure to do what a reasonable person would do. Software suppliers can be sued for harmful defects that could have been detected and corrected through reasonable software development practices. A warranty assures buyers that a product meets certain quality standards. If a product fails to meet its warranty, the buyer can sue for breach of warranty. Intentional misrepresentation occurs when a seller misrepresents the quality of a product. Most software manufacturers use limited warranties and disclaimers to avoid such claims. Now let's delve deeper into the role of regulations in software product liability. While traditional product liability laws apply to software, the rapid advancement of technology has led to calls for specialized regulations to address the unique challenges posed by software defects and vulnerabilities. Regulating software product liability involves striking a balance between promoting innovation and protecting consumers. Too much regulation may stifle innovation, while too little can expose consumers to risks. Policymakers face the challenge of crafting regulations that encourage responsible software development practices without stifling technological progress. Additionally, ethical considerations play a significant role in software product liability. Software developers have a responsibility to prioritize safety and reliability in their products, considering the potential consequences of failure. Ethical frameworks, such as the principles of fairness, transparency, and accountability, should guide software development practices to mitigate risks and protect users. It's important to note that software product liability laws vary across different jurisdictions. While some countries have comprehensive laws addressing software liability, others may have limited or ambiguous regulations. This variation complicates matters for multinational corporations operating in multiple jurisdictions, requiring them to navigate a complex legal landscape. Emerging technologies like artificial intelligence and the Internet of Things further complicate software product liability. These technologies introduce new challenges related to accountability, as the complexity of software systems increases and the boundaries of responsibility blur. Policymakers and legal experts must adapt existing laws and develop new frameworks to address these challenges effectively. In response to the growing concern over software product liability, industry initiatives such as bug bounty programs and responsible disclosure policies have emerged. These initiatives encourage ethical hacking and collaboration between security researchers and software vendors to identify and address vulnerabilities before they can be exploited maliciously. Consumer education also plays a crucial role in mitigating the risks associated with software products. By raising awareness about the importance of software updates, security patches, and safe online practices, consumers can take proactive steps to protect themselves from potential harm. Looking ahead, the landscape of software product liability is likely to evolve further as technology continues to advance. As society becomes increasingly reliant on software in various aspects of daily life, policymakers, industry stakeholders, and consumers must work together to ensure that software products are safe, reliable, and accountable. Software product liability is a complex and multifaceted issue that requires careful consideration from all stakeholders. From regulatory challenges to ethical considerations and emerging trends, understanding the intricacies of software liability is essential for fostering innovation while safeguarding consumer interests. The liability of manufacturers, sellers, lessors, and others for injuries caused by defective products is commonly referred to as product liability. There is no federal product liability law. Instead, product liability in the United States is mainly covered by common law, made by state judges, and Article 2 of the Uniform Commercial Code, which deals with the sale of goods. If a software defect causes injury or loss to purchasers, lessees, or users of the product, the injured parties may be able to sue as a result. Injury or loss can come in the form of physical mishaps and death, loss of revenue, or an increase in expenses as due to a business disruption caused by a software failure. Software product liability claims are typically based on strict liability, negligence, breach of warranty, or misrepresentation, sometimes in combination with one another. Strict liability means that the defendant is held responsible for injuring another person, regardless of negligence or intent. The plaintiff must prove only that the software product is defective or unreasonably dangerous, and that the defect caused the injury. Defendants in a strict liability action may use several legal defenses, including the doctrine of supervening event, the government contractor defense, and an expired statute of limitations. Under the doctrine of supervening event, the original seller is not liable if the software was materially altered after it left the seller's possession and the alteration caused the injury. So what have we learned today? Product liability involves the responsibility of manufacturers, sellers, lessors, and others for injuries caused by defective products. Claims can be based on strict liability, negligence, breach of warranty, or misrepresentation. Now let's put our thinking caps on. You are a member of the legal department of a software firm about to release its first product. How would you define the terms of the warranty for the software product? Consider the pros and cons of a simple warranty versus a detailed warranty. Thank you for joining me today. Remember, understanding software product liability is important for both consumers and software developers. See you next time.